Thanks for having me. Great to be here. Today we're going to talk about pre-suit, and I've broken it up into two basic buckets. The first bucket is to discuss a little bit about statutory pre-suit and some of the things that go into that. And the second thing is to talk a little bit about the concept of pre-suit. That is, what do you do physically as a paralegal, as a lawyer, as a person who's investigating these cases, either on the side of preparing for suits and the gathering of information, or on the side of the potential for defending for suits and preparing yourself and leveraging yourself in the best way, either to position those cases for early settlement or for resolution down the road in the best way possible to you. So let's start first with the concept of the statutory pre-suit. The idea behind statutory pre-suit was to create a vehicle for the early resolution of claims. There was, from a political standpoint, a fear that the litigation environment against physicians and other professionals was getting to a point where it was just out of control. And so the legislature, in its infinite wisdom, along with whatever the controlling party was at the time, decided, hey, you know what, we need to have some sort of intermediary type of approach or some preliminary approach or some sort of approach that would make you go about doing some things before the suit began. Give us a chance, if we're the defendants, to meaningfully evaluate and review this so that if we want to settle it, there's not a lot of public fanfare, there's not embarrassment, there's not problems, and we can get out of this and nobody really knows what happened. And that was the concept, the backdrop for that. It was also to potentially eliminate frivolous suits, because the idea was, instead of just suing your doctor or suing, any mental health or regular health care provider, and then sort of extorting them for settlement because the fear of they don't want to have to defend and have to be embarrassed by that, to create some vehicle that would make you, as the plaintiff, have some sort of evidence, something more than just you're upset with your doctor because things didn't go the way you wanted to, and you want to sue them. And so along came the concept of pre-suit. Pre-suit initially started under Chapter 766, which is commonly known as the medical malpractice pre-suit. And then eventually, as time went on and they realized there was lots of nursing home litigation going on, they realized, you know what, we need a vehicle for also dealing with nursing home litigation. And we've decided that since we have a separate chapter, a Chapter 400, different than a Chapter 766 concept when we're speaking about Florida, we ought to have a separate set of rules that govern the pre-suit of nursing home litigation. Now, I want to caveat by telling you that nursing home litigation, I am using that colloquial term. It is really claims that arise or come from suits against, or potential suits against, nursing homes, adult living facilities, ALFs for the cocktail talk, CCRCs, continuing care retirement communities, other facilities. It's not just the SCIF, skilled nursing facility, or the idea of a nursing entity itself. And so for those of you that may not be as familiar with the nursing home generic area, they sort of scaled the way in which they provide care by starting with, if I start with a generalized, you can live in a community that has access to health care, continuing care retirement community, and then you can get some care if you need it, but you're basically living completely independently. And then you think you need a little more care, and you have the adult living facility concept of you have your own place, but you have the nurse visiting you all the time, every day or what have you, and you still have access to those facilities and activities. And then you have the nursing home where I'm actually in a quasi-hospital. I'm in a facility full-time with a more conventional, regular, daily type of visitation that occurs like you would see in a hospital. And then you contrast that on the hospital side with the typical suits against either hospitals or against physicians, sometimes called healthcare professionals, healthcare practitioners, and different types of connotations of that concept. And so we wanted to understand these differentiations because there are different statutes that are involved. And you essentially have three different statutes that we're going to talk about in general. And that is your Chapter 766 statutes, your Chapter 400, which is your nursing home, and your 429, which deal with the assisted living facilities. And what I think would be best to do would be to address a little bit about the pre-suit on each one of those two categories. And when I say two categories, the nursing home side, as well as then get into the medical malpractice side. And what they did in the statutes is they created some definitional structure. That is, what they wanted to do was they wanted to create what are the types of cases that are going to be subject to this kind of litigation. And what are the types of cases that aren't going to be subject to this kind of litigation. So if you take a Chapter 400 case, okay, they created a definition, and I'll read the definition so you've got it. It governs claims for residents' rights violation or negligence alleging injury or death of the resident arising out of an asserted violation of rights under 400.022 or an asserted deviation from the standard of care. Chapter 429 involve claims of violations of the resident's Bill of Rights. In that resident's Bill of Rights, for those of you who aren't as familiar, the concept is that they created a certain set of rights that all residents should have, and if you violate those rights, there are different statutory violations that allow you to bring a suit based on that. And the reason why I read the literal words of that, as opposed to just generically telling you, is that you have to fit within this particular definition in order to be subject to the lawsuit. Now, you're going to find that it is a bit more comprehensive in the Chapter 400 and 429 scenario, in that you're going to have more cases that involve nursing homes and ALFs that fit within the statute than, say, a Chapter 766 medical malpractice situation. What do I mean by that? Let me give you an example. Let's suppose we have a fact scenario where the patient or the innocent person, let's call them, goes to the urgent care facility or goes to the hospital, and they're at the hospital and they're complaining of back pain, stomach pain, and the doctor talks to them and doesn't really give them the treatment they want, you know, at the speed at which they want. A lot of you understand that emergency rooms aren't always the speed demons of response that we might hope for. And the patient says, you know what? You're a jerk. Why don't you get with the program and get somebody in here who can help me? And the doctor says, that's it, I'm Baker acting you. Those of you who aren't familiar with Baker Act, that would be involuntary commitment, removal of clothing-related garments, okay? Lockage in a facility, possible, removal of all accessories, including phones and things in contact with the outside world. Those of you who want to date yourself, think of The Boy in the Plastic Bubble. Oh my God. Okay? Well, there'll be a quiz later on that movie. Okay? Now, I will tell you as a practical matter that then that person who gets out of that facility runs to their lawyer, runs to one of your able law firms and says, I want to sue that doctor. Okay? And the doctor is, he's negligent. He's done horrible things. And what you, as the lawyer or the paralegal advising lawyer, say is, okay, let's file a suit or let's go through pre-suit. Well, if you don't fit within the definition of medical malpractice, you might not have a case where you have to go through pre-suit. And as we'll learn when I read the definition of Chapter 766, okay, it has to do with the rendering of medical care and treatment, the actual diagnosis. And Florida happens to have a statute and some case law out there that says if you're suing for a violation of a statutory protection, you don't have to go through pre-suit. So even though it sounds like it's an action against a doctor for making the, quote, medical decision, poor one as it may be, it is conceptually not a decision that is going to be subject to pre-suit. And so you could go ahead and sue directly without going through some of the pre-suit discussions we have today. So I just use that as an example to illustrate to you that not every case involving a doctor is going to necessarily be required to go to pre-suit. Not every case involving a nursing home has to go through pre-suit either. And so while the overwhelming majority of cases will, you need to pay attention to that and recognize that in your analysis, whether you're on the plaintiff side or the defense side. If you're on the plaintiff side and you fail to go through pre-suit and your statute of limitations, the amount of time you have to sue, expires, you may have some problems with bringing your action. So you have to know whether you have to go through pre-suit. Now, a lot of people will say, when in doubt, give your statutory notice. Just send out the notice to the people under whatever provision you're on, the nursing home side or the medical malpractice side, because then you're covered, and then if you think you have a statute problem, well, file your suit after you do your notice and then move to abate your action while you're doing that. And you look at the definition and say, does this arise out of a violation of residents' rights? Okay, I'm going to be in 429. Or does it arise out of the improper care or deviation from the standard of care? I'm in a Chapter 400. Does it arise out of the rendition of medical treatment and diagnosis? I'm in Chapter 766. Or not. When the physician punches the victim, that may not be the rendition of medical care. When the nurse, accosts the victim, that may not be resulting out of care, or out of the medical treatment as the definition is going to show you. So conceptually, let's start with that concept that while the lion's share, while the majority of cases are going to be in this pre-suit, okay, so that you don't get the title of imbecile, okay, moron, loser, or some other word that you're not happy about, we might want to make some preliminary assessment, okay? And again, I use those terms understanding rightly that as a duly authorized agent of the lawyer, it is the lawyer that is the moron, imbecile, loser, okay? But just so that you're not somehow adhered by like that stickum paper stuff to the lawyer's decision because you happen to be in his food group, okay, we might want to engage in some of this basic preliminary analysis. Now, we're not going to have time today to go over exactly what fits in and what doesn't, those things. What we're going to talk about today is the concept of just some of the things you need to do, but in future sessions, we'll have a 75-part series on each and everything that you think you could, might, or may do, so that you're adequately protected, from that definitional thing that we spoke about earlier. Now, let's start with the nursing home violation of residents' rights, that concept, and talk a little bit about what happens and how you go about doing this notice and whether or not the notices you're doing are accurate and appropriate under the circumstances. And I would think conceptually that what you want to do is think about this as the suit before the suit. Think about this as we're really filing a suit for the plaintiff. We're calling it a notice. We're filing a suit because we're going to have some legitimate rights. Now, we're not going to court and stuff, but we're going to have some discovery rights. We're going to have some production rights. We're going to have some ability to talk to people. You know, if you're on the defense side, understand we're going to have some discovery rights. We're going to have some, ability to take some depots. We'll call them unsworn statements because we want to call them something else, but they're really depot-like. I love all the changes of words, All it does is serve to create more confusion, but good, okay? So anyway, and we're going to have some sorts of, we got a new right, especially under like Chapter 766, where we can directly talk to the guy or girl's treating physicians. How cool is that? Get a list of all their physicians and unilaterally pick up a phone and say, is the guy an absolute loser, moron, or imbecile? Is he a problem person or not? And you can't be on the phone watching and listening and hearing and, new right, pursuant to the amendments. So let's pay attention to the fact that conceptually what we have is this ability to do some discovery to find out from both sides. And also, too, you're able as the plaintiff to learn a little bit more about the case that you otherwise wouldn't be able to learn prior to filing suit. Makes sense? Okay? The defendant may learn a little more. Now, plaintiffs complain. Defendants aren't ever going to settle, and this is just another delay of 90 or 150 or 180 or 700 days or however many days you go on with this process, and it's just, and defendants say, oh, well, this is great because we get to screen out all those horrible cases that plaintiffs file that they know are frivolous and ridiculous and horrible, and we want to settle every possible case we can, and this is the greatest process in the world. Okay? But conceptually, however you approach it, whatever side you're on, recognize that this is a weapon on both sides. This is an ability to gather information which can help you in the assessment. If you're on the plaintiff side, I'm about to spend a lot of money. Medical malpractice, nursing home, experts, doctors charging $8,000 an hour, and all this other stuff, and defendants also doing that. I'm going to spend a lot of money. Then proposals for settlement are going to come in, and then I better feel really comfortable as the plaintiff that what my client's telling me and what the medical diagnosis that's out there says is fairly comfortable. Now, I can do that on my own by getting my expert, regardless of a pre-suit, to tell me, but generally speaking, it'd be nice to have some testing grounds to do that. And that's the concept. On the defense side, before I spend a whole lot of money, or before I, get myself into a position where I might be embarrassed because my facility, my hospital, has now got a lawsuit against it from some doctor who not only left a scissor in there, he left his homework and his cell phone in there, okay? I probably want to have some pre-suit ability to, let's date us all, shake the Etch-a-Sketch, okay? And start all over again. So this process allows us to do that. Okay, so how do we go about doing it? What do we do? Well, conceptually, in each of the statutes, you're sending out a notice, a piece of paper that says, hey, I want to sue you. This is my notice of intent to sue you, and I have to explain for your leaving the pencil inside of Bobby's stomach, when you should have, not done so. And you, along with 16 other people, are involved in this. Okay? And give some sort of notification. And a lot of lawyers call it a notice of intent because that's what the statute is, but it's essentially a letter. Okay? And that letter gives the defendants notice. And they tell you right in the statute how to do it. You can track the statute. We're going to talk a little bit about what each statute does. They're almost identical. Okay? They could have had, really, one pre-suit statute. Okay? And they could have had a little provision that said, okay, if you want to change things, then for Chapter 766, look at subsection C, and for Chapter 400, look at subsection D. But no, they decided to create separate statutes, but you're going to see some overlap. And I just want to go through some of the specifics of them so that you have an idea of, what has to go into these things and how it works. So if you look at what has to go in, just don't make the assumption that some old form that you were using from the person before you who purportedly was the expert that your lawyer or lawyers tell you that was the greatest paralegal ever invented, okay, that you're riding in the shadow of forever, okay? That magical unknown person, okay? Don't assume that that form is accurate without marrying it to the statute, and don't assume that because your lawyer has done it 300 or 3,000 times that the form is correct, particularly since statutes change, little language changes, and who I notify changes and what the impact of it changes. So if you think for a minute, if you say to yourself for a minute, okay, well, what has to go on there? The statute tells you. It says, in the notification, and we're dealing first with your Chapter 400 concepts, you got to notify what are the rights you're claiming were violated. Okay? What is the negligence that you're claiming occurred? What happened? What didn't happen? The person didn't have the railings up, they fell over, they broke their hip, you left them on the floor for 2 days, not a good idea, love and kisses you. Okay? You got to briefly describe those injuries, which is what I just did. Now, in terms of the notice, I'll just tell you, you can't write enough. Okay? You will see lots of notices that don't say much. You don't have to say much, but why not in a notice? If you have such a great case, why not just, write a novel? Why, in the Lord's name, would I ever write more than I need to write because I'm purportedly the plaintiff who doesn't want to tell you what, by the way, I'm going to have to tell you anyway, and it's going to take too much time? Why would I do such a thing? And why would the defendant want to see such a morass, a panoply, a litany, whatever other word you can think of stuff that is in a notice which is just supposed to say, I'm suing you for malpractice, or I'm suing you for violation of Chapter 400. Everybody has their own theory on things. My theory, okay, is the concept that why wouldn't I have had such a good case write everything? I want the defendant to read everything. Now, let's just parenthetically digress, shall we? And let's see who is the defendant who is reading this monstrosity of verbiage. Which is reason why, hint, hint, I might be writing something of a little more detail than spit out the notice Mary or John. Because the person reading that is not just the doctor. It's the hospital. It's the chairman. It's the CEO. It's the head of risk. It's an adjuster. It's the lawyer. It's the lawyer's boyfriend or girlfriend. It's your friends at a party. It's. Okay? If I have a good case, and I am of the position that many plaintiff lawyers are, that this process really doesn't often result in anything meaningful prior to suit, then letting them know the strength of my case might give them some pause about simply directing their paralegals to push buttons and ask for a bunch of healthcare statements and doing some free information gathering before the suit that they're then going to free information gather in the litigation. and then retake it again when they get close to trial and claim that they got to do update depositions. Okay? So I might want to motivate them in some way by doing that. So if you're on that side, you might want to do that. I can tell you that, have you ever read anything from the other side that had a lot of content in it, if you were the defendant, that made you say, wow? And if you did, you recognize the human condition. It works, okay? And if you're reading it and saying, wow, so are other people. So in this initial concept, recognize that it makes sense to be detailed. It makes sense to do that unless there is some overriding objection, because understand, you're not going to be able to hide that information. It's coming out, okay? And everybody's going to know about it, and the defendant will probably have 19 chances to reiterate that. So it's not like you're hiding something. And the concept is you can really tell a story and allow people to do this. Now, we could spend a whole hour on how to write these things, and I have a whole bunch of strategic things. Stay tuned for next week's seminar if you're back here in the room. We'll do one dedicated to just the coolest things in the world to write in a letter. What to include, what not to include. And there's some really cool things to include. But the concept is that if you think about it from the plaintiff's side, don't just send out a notice of intent that says, we are sending a notice of intent for violation of the residents' rights in the Chapter 400, and then the Bills of Rights in Chapter 400, and the notification is given to the following 6 people, and you can do that, no harm, but wouldn't it be better to tell them about all the violations and let them understand? You think you're hiding something? You think that maybe if you don't tell them that somehow you're going to spring something upon them? They're going to find out anyway. Pre-suit gives them a chance to find out before they find out. Okay? So you may want to consider that. And in the notice, it tells you that once you do that, in the Chapter 400 world, we trigger, let's date ourselves. You know that button you pushed called hold and the light would blink? Okay? Okay? When you see this video, we're going to have all these props. Like it's going to come up, it's going to say blinking light, blinking light, blinking light, blinking light. That's what happens to the statute of limitations. You know? And the music comes on, you know. So, conceptually, you're going to have a holding period. So that allows you as a plaintiff to know the statute's not going to be blown during that time period. Okay? Make sure you give notice to the appropriate people, but that's the concept. And then if you look in the statute, you will see it requires then people on the defense side to do something. What does it require them to do? Let's use the word investigate, evaluate, analyze, discuss, review. So you're giving them a chance in this period to do that. You have rights and they have rights. You have rights to get certain information in addition to that, and so do they. What does the statute say? The statute says you got 75 days, and that once you give it to the defendant must take action. They got to investigate the claim. They have to, and there's these litany of 4 items. And again, while I can tell you from memory, I'll read so that you understand that there are criteria. We got to have a claims adjuster, a risk manager look at it. Or we got to have internal review by counsel for each prospective defendant. Let me just make a little footnote to that. Each prospective defendant. Not one defendant, everyone says they deny. Each. If there are multiple defendants, each. If you're one lawyer representing multiple people, each. Okay? So, again, might only be a technical violation. If you're doing great work in your leadership role, notice I say leadership role because paralegals really run lawyers. Lawyers don't really run paralegals. But for those of you who are lawyers who are watching this, lawyers who run paralegals, when you're telling your underling paralegal, you want to make sure that you have something out there that shows that a review has been completed as to each defendant. I will tell you as a note, and I'll say this later, notice to one defendant is notice to all the defendants that are related. So if I'm noticing a hospital and I'm noticing a doctor and the doctor has a partner and the partner worked on it, that notice to one can be notice to all. We'll talk about that in a minute. But conceptually, let's just assume for the moment they've notified everybody. And so you make sure that you have in your file notification. And if you see that somebody else has done a notification, you want to make sure you have something in your file that shows you've done a notification to. A quality assurance committee authorized under any applicable state or federal statutes or regulations. So if you have some sort of committee that reviews, many institutions, nursing homes, ALFs, continuing care and retirement communities, law firms, hospitals, you're going to have some sort of committee. I make the joke law firms, they really don't belong, but I just said that to see if you guys were paying attention. Any similar procedure that fairly and properly evaluates the claims. Oh, let's just now say anything. I mean, what does that mean? Why do we need 1, 2, 3, and all the other ones? Because anything works. And it says each defendant or the insurer shall evaluate them in good faith. So you have to make some good faith opportunity. And generally speaking, you're going to have that. But you just can't you send it to the doctor, and the doctor just sends back and says denied. It's just not, that's not good faith. And you will find that both on the defense and the plaintiff side. And I would suggest to you that if you were one of the co-defendants and you saw that one of the doctors was doing such an unusual and rare thing, that you might want to reach out to them and say, why don't you put some evaluation in it? Why don't you ask your partner or somebody else so you can say that you made some good faith evaluation, okay? Instead of being subject to sanctions that make everybody look bad and delays and other types of things. So be aware of that. Before those 75 days are up, you got to accept, reject, or do nothing. Now, if I were writing the statute, of course it'd be shorter and it wouldn't say do nothing. It would say accept or reject or be sanctioned to the fullest extent of law, including a minimum of $10,000 per moment that you did not accept or reject. If you can't write a 6-letter word or a 7-letter word, accept or reject, shouldn't you be banished from this earth? However, they seem to suggest that while you can act in good faith in evaluating, you don't have to tell me that you did anything, apparently. I don't write the statutes, I just drive trucks over them. Now, once that happens, you get the exceptions or the rejection or the nothing, you have a period of time with which to sue. So the whole button, remember the whole button? Blink, blink, blink. The whole button's pushed, and now you have your 60-day time period under there with which to sue. Don't make the mistake of not suing. If you're smart and you're the plaintiff, you will have prepared your suit already. Most of you are going to have form-like suits where you're not filling in a lot of information. Form-like, okay? And so you're only going to be filling in some information. If you have some really good software programs, you can actually dump in all the information. It will actually formulate and populate the complaint automatically for you with all that wonderful data in. And then it gets sent off and you sue. So make sure you don't forget that you can't just take all the time in the world you want. Now, let me caveat that 60 days by saying that if you have a lot more time in the statute, then you have a lot more time in the statute. So if on January of 2018, you had an incident occur, and then you went into pre-suit and you got done with all this stuff in August, you're not barred from the statute of limitations unless you file that suit more than 2 years after, or whatever the applicable statute of limitations is. You're not, the 60-day rule doesn't trump the SOL, statute of limitations, for those of you who want to continue the cocktail talk and conversion chart. Okay, if you're wearing your decoder ring, you don't need to have the conversion. The concept is that what you're having is the ability to, at the very worst, have that 60-day period. So that's the concept. Now, anything you engage in, happily for, perhaps more for the defense than the plaintiff, anything you engage in, the statements and discussions and reports, they're not admissible. They're not usable. Not 100% sure why you would want somebody to do an analysis and then say that analysis is not usable if it involves a medical diagnosis, because wouldn't you believe that that would be accurate, and what would you be afraid of? But in its infinite wisdom, they're trying to promote a concept of openness and evaluation. So they say anything on either side is not going to be able to be used in the future. There's a whole bunch of debate about what that means, usable in the future. It says for any purpose. There's a whole bunch of questions about what you can impeach with. There's been a dialogue across the country. I could impeach with my shoe if I wanted to. The concept is that you can usually impeach with just about anything. But the language in the statute concept is to try to eliminate any chance of you using that in any way, shape, or form. So just keep that out. Additionally, the people who render opinions are generally immune from suit. Wow. So if they say something that is preposterous, you can't sue them with a tiny little asterisk. You can report them. They can still be disciplined. And so when your lawyer is doing the Fred Flintstone suckin' frussin', because that lawyer knows, or better yet, you know and you educate your lawyer to that it is such a preposterous position to take, then what happens is you have the ability to at least have some remedy of a disciplinary board, a licensing board, agency for healthcare administration, blah, 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 to remediate that, and they view that as some sort of mechanism. So keep that in mind, that it is not true impunity, but it is impunity from civil suit, okay? And you can have in the medical, in the nursing home environment, you could have a nurse, because it is a nursing home, you could have an appropriately licensed practicing nurse, professional, to be able to render that analysis and or affidavit in that regard also on the nursing home side. Pre-suit discovery, well, you can have the right to talk to people. You could take unsworn statements and you can discover things, okay? So imagine you're a litigator. The process of getting the unsworn statement is just like a depo. Do a notice, try to cooperate. If you're taking the deposition unsworn statement of the plaintiff, try to make sure all the lawyers are doing it at once. You can't take 9 different unsworn statements. Come on. If you're on the defense side, you need to make sure you as the plaintiff, you cooperate and make sure all the lawyers and doctors and spouses and uncles and children are available to be there. Okay, so keep that in mind. You've got to cooperate. You've got to operate like that. And my suggestion to you, which is also in the 46-hour writing seminar that we do, that when you write letters that say, we need to take the deposition of so-and-so, or in this case, the unsworn statement of plaintiff, here are 38 days we're available. Do not, underline, do not, underline, do not, do not, do not, do not. Dear plaintiff's lawyer, we want to take the unsworn statement of your plaintiff. Give us some dates. Do not give me some dates in 2 days or I'm going to allow you picking a date. Don't. It's a loser argument. You look like a moron. You write, dear plaintiff's lawyer and paralegal who's really reading this. It's a pleasure to be working with you. We're going to need to take the unsworn statement of the plaintiff. We'd like to do that as expeditious as possible. Here is 12 different days, 46 different days, which are available. If you'd be so kind, as you know, there is a shortened time frame for engaging in this pre-suit discovery unless you'd like to extend it to an unlimited period of time. We greatly appreciate your anticipated and wonderful cooperation in providing us with one of those dates, et cetera, et cetera, et cetera. A lot better letter when you show the judge, when you show people, hey, listen, we're doing everything in our power when you eventually have to claims of they're not cooperating. And you should do that on both sides. So it's important to make sure you understand that you do have these rights, but you need to cooperate. You can ask for production of documents and do those things. If you get a settlement offer, you got a certain amount of time, 15 days to accept the offer. You got mediation rights. We talk about the mediation rights, and they're set forth in the statute. You got 30 days thereafter to mediate. And some things which are going to overlap in the 766 environment, which are almost identical, are things like you have to have a medical expert review it. Yeah, you have to have some corroboration of what you're claiming is or is not the negligence, is or is not the violation of residents' rights, is or is not that particular fact which you're claiming is true or false or supported or unsupported. In Chapter 766, a little bit different than Chapter 400, they actually have a procedural rule, Rule 1.650, which governs the procedure of how things work. Statutes govern substance. Rules govern procedure. How statutes are satisfied, evaluated, utilized, enforced, complied with. That's rules. Statutes are, this is what has to be done, this is the requirements, this is the elements, these are the things which constitute a violation. 766, another seminar we could talk about, has some things that look like what's in Rule 1.650 about what you can and cannot do that have a tendency to overlap, but conceptually, if you look at the rule, it will tell you procedurally what you need to do. And I will tell you that aside from differences in days, okay, instead of a 75-day period, you got a 90-day period in 766. Okay. They have a few different people who can review this. Similar internal review by a qualified claims adjuster. Similar. Ready for this? Creation of a panel comprised of an attorney knowledgeable in the prosecution and defense of medical negligence action, a healthcare provider trained in the same or similar medical specialty as the prospective defendant, and a duly qualified claims adjuster. That could constitute that panel. So if the claims adjuster for some reason didn't want to do it themselves, which it sounds like number one, you could get some people together to do it. Not sure, just as a side note, whether or not if you had the adjuster doing it, why the adjuster would then want two other people involved. But that's what the statute provides. A contractual agreement with the state or local professional society of healthcare providers which maintains a medical review committee. You could have them look at it. My favorite one, any other similar procedure in the entire universe that you could possibly think of, which fairly and promptly evaluates the claim. Not that I have any feeling about that one. You got to evaluate it in good faith, and there's some language in there additionally in the 766 about, screening committees and things like that. Same sort of, within that 90-day exception or rejection or do absolutely nothing. You can admit liability in Chapter 766, which is a little bit different. The hold button that you were talking about in the 75 days, 60 days, whatever the days are, now it's 90 days on the statute of limitations. Okay? Might want to look, I've cited some cases in there that talk about how you give proper notice, some things that are important about that, and I recited some of the important things about 1650 that you may want to look at when you're doing that. Same sort of immunization from civil liability, work products not admissible, not discoverable, failure to comply can result in sanctions, and tough to get them, but they're out there. But conceptually, you're getting an understanding of the things you need to do to make sure you do the proper compliance on both sides, not just the plaintiff or the defendant. If you're the defendant, you have no problem in drafting a response that has the same sort of detail to respond to what the plaintiff said, if that's what you want to do. Or you can just say, we reject the claim. Now, in the short time that we have left, I just want to mention some things about the generalized pre-suit, which I could spend a whole session on also, and that is the concept of, what do you physically do? What do you actually do if you're thinking about suing or not suing? How do you gather evidence? What do you do? And conceptually, what you try to do is you try, if you're on the plaintiff side, is I want to discover every possible fact, every document, every witness. So facts, documents, witnesses. I want to know what it is in terms of the finite universe of facts that could support or destroy my claim. I want to know the finite universe of documents, medical and otherwise, that could support or destroy my claim. I want to know all of the witnesses who might provide information that might support or destroy my claim. It is very easy in the scheme of what you do to get mired in what I call the button pushing of you don't really think widely and you're just trying to get that project done, and so you push that button to get that notice out or not, and you're not thinking about conceptually that lawyer may not be doing all of that diligence. And so you are well served to create procedures and policies in your office that allow you to do what I call the shrimp netting. I talk about this in Discovery, of grabbing all the information, bringing in all the shrimp, and then pulling out the lobster. Okay? So what you want to do is make sure in your investigative analysis, whether you've created a 700-item questionnaire or not, that you have made sure you've asked all those questions. I will tell you, we have a form in our office, which I'll happily send you, on personal injury, for example, that asks about 300 questions. If you answer these questions, you know everything there could possibly know in the world about the case. Whether you want to ask them in a given case or not is your choice. So what you want to do is when you're assessing that plaintiff, make sure you go through and say, tell me every single person, in your first meeting, second meeting, tell me every single person who knows anything about this case. You told your dog, I want her name. Everyone. Okay? Who are they? What's their name? What's their address? What's their phone number? Who are they? What's their name? What's their address? What's their phone number? What's their email? Every person. And then when you go back and you finish with them, you're going to write them a letter and say, here's all the names of all the people, the phone numbers, everything. Is there anybody else? 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 Okay? The tape's going to say that, and they're going to think it's sticking. Kind of a humor side thing. It's a video thing. Okay? So, you want to make sure you do that. And throughout the case, if you have ticklers and you set up reminders, you can do the anything else letter every month on all your clients and push the button and say anything else. Same thing with facts. Okay, take me from DNA to the present. Okay? And just a quick note about questioning is the concept that you need to appreciate, you need to understand that your clients on the plaintiff or the defense side are never going to tell you everything. Either because they don't remember, they're not prompted, or they don't want to. Okay? Now, some may want to, but just not remember, not be prompted. So you have to make sure that you use triggers. And we call it the baby step technique, and that is the concept that what you're doing is you're asking very, very, very small, tight questions. So, when was the first time you talked to Dr. Muckenfuss? Okay? Now watch this and do this. Okay? I talked to him on January 2nd of 2018. Okay. Tell me how you came to meet that person. Bobby, my friend, told me about him, blah, blah. When you got to the office, what's the first thing that you did? Did you say hello to the receptionist? Did you grab a mint? Did you pick up your cell phone? Okay, and they gave you forms? Oh yeah, I went to the front, I checked in. They say, hi, Mr. Major, here's your forms. Okay, what did you do next? Okay, and what happens is when you start doing this, you're going to find an incredible amount of information coming out. And to prove my theory, which has been researched and data tested by over 1,000 people and is 100% foolproof, when you leave today, I want you to go to your significant other and I want you to engage in the following question technique, which will forever change your life. In the best way possible. And that is, you must ask them a question that will not result in a one-word answer. And then from their answer, you must attempt to ask questions for as long as you can go without getting a one-word answer. Stunningly difficult as this is, you will not believe the amount of information you will gain. If you ask a spouse, friend, relative, anybody, and they won't even know. So not, how was your day? Great. Tell me the things you did today. Tell me the things you accomplished, son. Give me 3 things that you did that you felt really proud of. Give me 4, whatever it is. If they say none, zip, no, nada, you lose and you have to start over again. Okay? You will find this to be a challenge. But once you start doing this, you will not believe how incredibly productive this is for your skill in gathering information both from witnesses, opponents, your own lawyer, other paralegals, and so forth and so on, and how it will help you to, when you question people, to go through those baby steps. At another session, I'll spend an hour or 2 with you and tell you how you can actually do that. But conceptually, you guys are seeing I'm getting facts, witnesses, and documents from either the plaintiff or the defendant. If you're this deliberate, and if you use one final technique, and that is called the exhaustion technique, and that is when you think you have everything, you repeat that with the following words. Anything else? Okay? So, you said you went to the facility, you got the doctor, you went to the facility, you got the doctor, you spoke with the doctor, you got the forms, they gave you 12 pieces of information, you went over your procedure, you did this, you did that, you did this, you did that, and you did this. Right? Exactly. Anything else? And just make sure that after you say anything else, and they say no, you utter the immortal words that all great leaders should utter. And that is, anything else? I hope you enjoyed it.
Ladies and gentlemen, join me again as we give a warm welcome and a thankful appreciation to Mr. Major for all the information he's given us. Thank you for your time.
Thanks. I'm sorry. So let me just tell you guys, I know you're going to have a break, but let me just tell you, if any of you like these kinds of presentations, okay, what I'd encourage you to do is grab one of the mics and tell the video people, hey, listen, I really liked it or not, and we'll do more of them. If you didn't like it, grab one of the mics and tell them what you didn't like about it. But conceptually, that will help us. We're building something for the paralegal organization locally and nationally, and we want to do something of things you guys like. And if there are things you liked about the seminar, we want to do more of it. So we appreciate that, and you can go in front of any video camera with this mic I'm about to give you, and please, tell them whatever it is you think. Thanks so much for your time. I'm sorry.
Wait. We want to thank you.
Oh,
for
thanks so much.
speaking. And I personally want to thank you because out of all the attorneys I've ever worked for, not one has ever respected what I did, backed me in every way, paid for everything I needed as a paralegal, and supported all of our paralegals from Broward to West Palm to all over. So we love you.
Thank you very much.
Hi, my name is Sandy Joshua Scott. Yes, thank you. We definitely, as a paralegal organization, need more informative videos such as this helping us so that we could be successful in helping our attorneys. Thank you very much, and you did a wonderful job.
As president of the Broward chapter, Scott Major is phenomenal. Everyone loves him. When he has seminars, he keeps everybody laughing. He loves to teach. He backs our paralegals. I think he's an asset. And he's hilarious. And everybody thinks he's cute too.
I'm a Florida registered paralegal, and I just wanted to say that I'm attending Scott Major's discussions here today, and they are wonderful, grabs your attention, very informative, funny, but you also learn a lot. So I'm really happy to be here today, and I think we should have a lot more of these. Thank you.